Chilling Show for today. We welcome trial and appellate lawyer Jim Pikl, Scheef and Stone out of Texas. An interesting story there on a restaurant refusing service for people with face and neck tattoos, at least at some of its branches. Attorney Jim Pikl, thank you for joining us today on the Chilling Show.
Thanks for having me on, Rob. I appreciate it.
All right, so you have a restaurant there called Little Woodrow's, and they decided, at least at a couple of branches, they were going to do what?
Not serve people who had visible neck and face tattoos.
All right, so there was probably some reason for that, some stated reason. It wasn't just a random request. What did they say when they were asked about this?
Well, I didn't ask them. I don't know. They've imposed a dress code for their establishment, which is perfectly okay to do. I assume, from what I know about neck and face tattoos, a lot of them are associated with gangs and prison, and maybe they just didn't want that element in their restaurant with their other customers. But like I say, I haven't asked them. Okay. So what happened then? There were a couple of people who were banned, and then this got into social media? Yes, there's no lawsuit yet on it, nor would I think such a lawsuit would ever be successful because, like I say, this is really just a dress code, and you see signs all the time in restaurants saying, no shirt, no shoes, no service, or we reserve the right not to serve anybody we want, and except for a few protected classes under federal law, business owners have the right to refuse service to anyone.
So this is what I wanted to ask you about. I remember seeing those signs as a kid. I see very few of them now. We reserve the right to refuse service to anyone. Under what legal principle, I mean, I agree with that, but under what legal principle does that operate, and have there been court cases about that?
Well, there have. Federal law changed in the 1960s, 1964 specifically, when the Civil Rights Act was passed under President Johnson, that created a list of 5 what are called protected classes that public accommodations, government agencies, things like that cannot discriminate against, which cannot refuse service to. And those 5 suspect or protected classes are race, color, national origin, sex, and religion. But aside from those 5 things, and then, of course, in 1990, Americans with Disabilities Act was passed by Bush 41, and that included in the protected classes people with disabilities. Other than those 6 now protected classes, businesses are free to discriminate against customers or employees, for that matter, on any other basis they want.
And I guess the same would be true of the other side. I mean, any customer can discriminate against any business. I mean, you can't be compelled to do business with somebody, can you?
No. Well, can be compelled to buy Obamacare or pay a penalty, but yeah.
Well, that may be changing very soon. So does all of this, I mean, where are we going in the future on this? I think we're going to have more rational courts here, but I'm concerned about some of the other cases where people have been forced to provide services to people that they didn't wish to based on religious reasons. Are these things protected? Are the religious liberties protected?
Well, it's not so much the religious liberties or the class of the provider that we look at in civil rights cases. We look at the class of customer. And so, for instance, in Oregon, where the bakery decided not to bake a cake for a gay wedding, the courts there flipped that upside down, and they said that the Christian owners of that business could not invoke their religion as a reason to discriminate against or not do business with the gay couple that was trying to get a wedding cake made. That's really backwards, Alice in Wonderland kind of backwards from what civil rights law really is. And the fact that the Oregon courts upheld it, between you and me, doesn't really surprise me very much.
Right. Do you think we're going to see a sea change in the courts, not only at the Supreme Court level, but do you think this will trickle down to the federal courts and we'll see more rational constitutional judgments?
Well, we'll see what President Trump does when he appoints the 300 or so vacancies that are currently on the lower courts and the Supreme Court. That's one of the president's greatest legacies, is to appoint the federal judiciary, and he or she can really affect 20, 30 years into the future, depending on who they appoint to fill those positions, because, of course, federal judicial appointments are life appointments. We don't know what Trump's going to do. We know some things he said on the campaign trail of things he plans to do, but now that he's won, who knows?
And we should say that the Little Woodrow's case ended up with them rescinding their policy, not for any legal reason, but perhaps just because it was bad for business or they thought they were going to get a lot of negative attention?
Right, yeah. Business coercion, boycotts, things like that can have a huge impact on a business's business, way beyond what a court case could. Because court cases take time, they take money, you got to hire lawyers, they're expensive. Whereas public boycotts, things like that, obviously are of concern to a business owner because he doesn't want his business suffering based on whether his criteria are legal or otherwise. And I think that's what happened with Woodrow's is they just decided, look, this is just causing too much negative attention. We'd rather get past this, and so they rescinded their policy. Attorney
Jim Pikl, if people want to reach you or contact you online, where can they do that?
Yeah, our firm site is www.solidcounsel, which is selcounsel.com. That's the firm's website, and I have an email address on there. They can get a hold of me there. Thanks so much for shedding some light on the case. We appreciate it. Thanks for having me on, Rob. I appreciate it.
Okay. A very interesting case.